right, let's talk about this and some other legal matters in the news at the moment. We speak to legal analyst Mpumelelo Zikalala. Great to have you with us as always. Do you agree with the presidency? This is not a biggie because the ConCourt didn't even get to the technicalities. Maybe it shouldn't have even gone to their court in the first place.
Well, it is a biggie. It's a point in which a certain matter that you have taken to court has been technically thrown out because the court is saying it is not that important. Go to a lower division where they'll be able to ventilate the matter in a much more comprehensive manner. The court also understands the importance of this matter and understands and respects the rule of law and the manner in which this high or jurisdictional matter should then be undertaken. So the ConCourt was saying a very important message to the president in saying that you may be the number one person of the country, but we're not going to bypass all these other provisions and steps that are available to you because you simply want to have an audience with us. Start at the provincial division before you come to us, and only on that basis you can then come back and say to us, let us listen to your matter. From a technical basis, I think Parliament, the opposition parties in Parliament can then have a leg to stand on and say, you know, if you listen to Hansard and the type of arguments that were made by the parliamentarians, most of which were relying on this particular matter, which has been thrown out by the court on the basis of technicality, did you really apply your mind to it? Or are you simply stating matters or regurgitating what you have been told in your caucuses? So apply your mind in this matter because it does not deal with the merits, whether the president is guilty or not. It simply says, allow a process in which the president will then be able to provide further evidence to what he has stated. We are in this position because it is the president himself that said, yes, there was money which was found in my premises. I was engaging in other activities of which the constitution is very clear that it cannot be done by the president.
Does this link to a fundamental debate that has been held in South Africa? We've even heard from a judge saying political issues shouldn't land up in the courts. There's a space for politics and then there's a space for the legal system. The president wants the courts to determine his fate. Could it be that they actually send it back to Parliament and say that is where your fate should be determined?
It could be, but that can only happen after a very long time. Let's remember that when it goes back to the provincial division, which is the Western Cape division, which I think the president is going to do, by the way, if there's any party that loses at the end of those arguments, they can still go to the SCA, they can still go to the Constitutional Court. So by the time the matter goes back and is properly announced or the final decision has been reached by the Apex Court, it could be more or less 24 to 36 months before this matter is brought back to Parliament again. And what are you bringing to Parliament? That's the most important question. Parliament was asked the question, do you want to go on and be able to deal with the matter based on hearsay, or do you want to form a much more formal sitting that will be able to determine these particular matters, listen to evidence, and give more powers to the presiding officers so that they're able to collect all that they need to collect and be able to move on? So those are the type of things that which Parliament will have to deal with at the end of the day. And it is purely, for a lack of a better word, with utmost respect, a waste of the court's time to allow a proper parliamentary process to take place. And that particular parliamentary process will be able to deal with all the concerns that have been raised by the president. So you can't go to court whenever you feel that politically we have no space to run to and expect the courts to come to your aid. The courts are going to answer in this particular manner and say that we have a rule of law. Our constitution is very clear as to how to deal with matters, follow the proper processes, and you'll be able to get the results that you want.
But finally, on this matter, whether by design or coincidence, the legal process does stop the president being held account in Parliament. Well, certainly ANC members can always say, no, we will wait for the legal process to end that you are suggesting could be a lengthy one.
Yes, they can say that, but we also remember that we also employ another important duty on them to say that whenever you take decisions in Parliament, you must make sure that they are rational. So there must be some plausible explanation of saying that, but for what evidence which is in front of us, this is the decision that you have taken, and a reasonable politician or parliamentary individual would have taken that decision being faced with the facts that they have. Now, in this case, the opposition parties, as they're taking the decision on review, are going to say, look at what the ConCourt has said. The parliamentarians have not applied their minds and they've simply applied their party lines. On that basis, they've delegated their duties and simply said, we are not going to think carefully to the best interest of the South Africans in terms of this particular matter. We are simply going to defend our president come hell or high waters, which is something that cannot be accepted in how Parliament should work. So it does add in the favor of the opposition parties in Parliament, because they're going to come back and say, even the ConCourt's agrees with us based on the matter on technicalities, maybe not on merit, but on a technicality. You are able to deal with those things in a much more clearer manner. So allow Parliament to validate the process to its entirety, then you can go to court.
All right, let's look at another parliamentary matter. And the Section 194 committee has turned down a request by the Public Protector Busisiwe Mkhwebane to delay the testimony of her predecessor, Thuli Madonsela. Now, I think there will be a lot of interest, so this is going to happen. Thuli Madonsela's testimony, if you can call it that. And in many respects, these women are seen as chalk and cheese. How can Thuli Madonsela's words help Busisiwe Mkhwebane or hinder her progress with regards to trying to keep her job?
Now, I think what she's trying to do, Advocate Mkhwebane, is to then say, let's look at the Office of the Public Protector and how it works. There's not much difference in terms of the procedures and strategies that I apply. It's just that there are certain instances in which people were a bit critical as to how I was doing my job, and there are certain matters that have been taken on review that I may have lost. But in the overall performance of the office, I think I've done a good job. I've got clean audits on the number of times in which I've done investigations. In a more or less the majority have been successful and been able to get redress of the applicants or the complainants, which is what the Office of the Public Protector ought to do. Now, if you then are able to bring Advocate Madonsela to come in and testify, what she can be able to do in favor of Advocate Mkhwebane is to say, these are the same strategies that I've utilized within this particular office. Yes, they are acceptable. It does not mean that when we engage in those particular activities, we hate other individuals or do not want to be part and parcel of it. It simply means that we want to hear the best of what is stating in that particular process, and it ends there. So I think that's the type of similarities or same manner of providing a level of service in which Advocate Mkhwebane is trying to do. And these particular delays are going to speak directly to the procedural fairness of the whole process. If ever this matter would go on review, all these instances in which the chairperson is saying no are surely going to be raised. And the most important question that should be asked by the court is, were the prejudicial to Advocate Mkhwebane? Did they allow a fair process to be undertaken by the committee? And if the answer is no, then the findings of the committee must be specified.
Yeah, her lawyers are raising everything. Well, we will watch that with interest. Finally, in 30 seconds, Didi Mabuza has resigned as deputy president. He in fact, resigned a long time ago, but the president asked him to stay on. Just explain the legalities around that.
Whenever vacancy has occurred, the constitution is very clear that it must be filled in as soon as possible. So the president will have to appoint a new deputy president as soon as possible, so that that particular vacancy does not take place within an extended amount of time. Remember, the deputy president is the leader of government business, a very important position, and it must be occupied on a daily basis. So I think the president is forced this time to do a cabinet reshuffle, and he does not have the luxury of time. And in order to apply his mind, he simply has to do it as quickly as possible.
Yeah, and the speculation was that he was trying to hold that off, therefore asking the deputy president to just hold in his office while he could think about that. So maybe we will soon know who the Minister of Electricity is. Thank you for your analysis, as always, legal analyst Mpumelelo Zikalala.